Hello and welcome to Civility and Solutions, a podcast brought to you by your Court Services section of the Supreme Court of Ohio. I am your host, longtime justice enthusiast Kate Munger. This is a podcast about inspirational ideas for courts from across our 88 beautiful Ohio counties. The idea of a podcast was conceived as a way to be able to present content that was developed for the 2020 Dispute Resolution Conference. That conference was unfortunately called off for that plan-crushing pandemic called COVID-19. We are using this podcast so we don't lose that valuable symposium content. Today's topic relates to arbitration. My guest today will introduce you to the law and practice of international commercial arbitration as an alternative to litigation. We'll go through some of the basics from entering into an arbitration agreement to running an arbitration. By the end of the podcast, you'll know the role of state and federal courts in international commercial arbitration, including enforcement of the arbitration agreements. The views expressed by guests to this podcast don't necessarily express the views of the Supreme Court. We are happy to be able to use this platform to share solutions and challenges with courts and any listeners who want to stay on the cutting edge of dispute resolution and court services issues. Joining me today are two world-traveled professors, Professor Benjamin Davis and Professor Vera Korzun. Thank you so much for being here today.
Great to be here.
Great to be here.
Thank you. Professor Korzun is an associate professor teaching international business transactions, contracts, and arbitration at the University of Akron College of Law. Professor, what is something special about the University of Akron College of Law?
Well, it's the place where students are very much interested in international law, international business transactions, and my passion, international commercial arbitration.
Great. And you would know a good school because you've attended many. Professor Korzun received her Master of Laws degree from the University of Michigan, her Master in Law and Economics degree from the University of Hamburg, an LLM degree in International Business Law from Central European University, her Doctor of Judicial Science degree from Fordham Law School, and she has a PhD degree in law from Belarusian State University, where she also earned her first degree in law. So you must really, really enjoy learning.
Yes, and I think a part of it is law. You know, we are necessarily connected to the jurisdiction where we study. And if you want to do international, you have to expose yourself to foreign jurisdictions. So this is the reason why.
So what's a difference that you notice between universities abroad and universities in the US?
I think the style of teaching and learning, in Europe, I think it's much more repetitive in terms of repeating the knowledge that you learn from the professor and presenting it on the exam. And I think it's much more engaging with cases, especially in the United States, where students are expected to be critical and also argue on both sides of the deal. So this is, I think, the biggest difference.
And I know you must be working on some article or other scholarship right now. What are you currently studying that you're excited about?
I'm excited about international investment arbitration, which is a hybrid method of arbitration. And I'm looking into the role of investment tribunals when it comes to the enforcement of non-binding soft law provisions of international law. So this is my current project.
Very neat. Thank you. Professor Davis is a professor of law at the University of Toledo College of Law. And his true claim to fame is that he was my contracts professor when I attended law school. I always enjoyed your class, Professor Davis. And I hope I left an impression, because after he taught us the ways to avoid enforcement of a contract, I wrote a parody tune to 50 Ways to Leave Your Lover called 8 Ways to Avoid Enforcement.
Yes, an excellent development. Absolutely. Great, brilliant.
Thank you. So how long have you been teaching at University of Toledo, and have any other students written parody songs for you?
Actually, I don't think any other students. I'm thinking 17 years I've been teaching at the University of Toledo. I came up here in 2003.
That's great. Professor Davis, before you taught law, you had a very interesting career experience as the American Legal Counsel at the Secretariat of the International Chamber of Commerce, International Court of Arbitration in Paris, France. Can you tell our listeners what you did in that role and what that was like?
Yes, it's located in Paris, and basically it's one of the, if not the premier international commercial arbitration institutions in the world, and it's the most highly supervised form of international commercial arbitration that's done there. And basically, I was the buffer between the Court of Arbitration, which made a series of administrative decisions from the starting of the arbitration all the way to review of the award done by the arbitrators, and with the arbitral tribunals and the parties with regards to arbitrations that were done under the rules of the ICC, or there were some mediations that were done. And on occasion, we would kind of help countries that asked for advice on how to improve their arbitration laws. We also did seminars around the world on international arbitration. And the thing that was wonderful is that I think there were parties probably from 100 countries, with arbitrators probably coming from 60 countries, and arbitrations basically going on 24/7 somewhere in the world. I think at one point I counted, I had arbitrations that were going on in 30 different countries. And so it makes for a purely international environment where I worked for 10 years with probably dealing with directly 1,000 international arbitrations of all kinds.
Wow, that must have been so interesting and so many different topics and concerns.
Oh yeah, sort of what can go wrong in an international commercial setting with anywhere from two entities. There were actually even a very few employment contracts, all the way up to disputes between companies and governments about, say, building something in a country, those kind of things. So it was pretty amazing.
That's really neat. And what food in Paris do you miss the most now?
What food do I miss? Probably the French croissants in the morning. There's a way they do them. I can't explain it, but we've gone and gotten some here, and they're good, but they're just not the same as the ones you could get at a little bistro in the morning. Get a cup of coffee and an espresso and one of those croissants. There's a lot of great French food. Okay, I'm married to a woman from Quebec who's a great cuisine, a great cook. So I get some of that all the time. But we both miss the croissants.
Oh. All right. So you are both set to present about international commercial arbitration at the Dispute Resolution Conference. And are you ready to try that topic on our new podcast format today?
Let's go for it. Yeah, absolutely.
All right. Well, let's start with the basics. Professor Davis, what is arbitration? How can it be used in place of litigation?
Okay. Well, so arbitration is basically a procedure by which a private tribunal renders a decision that it adjudicates a dispute that has arisen between some parties, and renders what is called an award. That is what the judgment is made by them. And the private tribunal gets to do this usually because the parties have an arbitration clause. I'd say 99% of the time, you will have already an arbitration clause in a contract, and that will foresee this private tribunal doing this adjudicatory role. It's different from litigation in that in litigation, you can have the first instance court, and of course, the district court, and you might have an appeals process up through it. Basically, after the arbitral award is rendered, there are very limited grounds to which to attack the award in most countries. So it really is got a very strong sense of finality to it. It's also different from mediation because at the end of a mediation, you might come to an agreement on how to resolve the dispute there. Well, that's, again, a contract, and you're looking at breach of a contract or not if the mediation agreement is not fully performed. Here, you have actually an award that can be portable, meaning it can be literally be taken into a lot of different countries in the world and ask those courts to essentially enforce what that award says. And for the most part, again, there's very limited scrutiny done by courts to second guess the arbitral tribunal. So it's a very powerful way of resolving disputes, particularly for people or companies that are from different parts of the world who are really a little hesitant to be put into the legal systems of their counterpart in the deal. You know, we could, for example, imagine a negotiation where one side says, we want to have state courts that apply, you know, then they're thinking Ohio state courts. And let's say the other side is a Turkish company and they say, yes, we agree. State courts, downtown Istanbul state courts. All of a sudden, both sides are looking at different languages, different legal systems in terms of civil codes and all that. And most folks are a little hesitant to be put into the system of the other. And this is where international arbitration is developed as a way to resolve those kinds of issues about how disputes about the contract can be resolved.
Now, I know I've signed a bunch of things that have the small print and it always says arbitration. Parties agree to arbitration. So actually, I've probably entered into arbitration agreements myself as far as agreeing to arbitrate. But what are some other examples of situations where international commercial arbitration would come up?
So you have, if you have a cell phone, you've entered an arbitration clause, by the way. So the United States itself has a very broad vision of what is arbitrable. So employment agreements, people getting hired for a job, consumer contracts, in addition to commercial contracts that I've been talking about. That's different in other places in the world. For example, in other places in the world, you can't have an employment arbitration, or it's very limited what can happen. They have specific courts for that. But for the kinds of problems that you could see in an international commercial arbitration, it could range from a dispute about creating between a manufacturer and a designer of a computer, or it could be a dispute about somebody's got a distribution contract and one side is saying that the other side is not complying with the obligations of the distribution contract and they want to terminate the distribution or they want to get paid back money. It could be a construction dispute where one side said it made everything properly and should get paid, and the other side said, no, you didn't make it properly. And it's a dispute about whether it was a design flaw or it was a performance of actually building the thing. You could have disputes between banks about who was supposed to properly bear the loss of something that happened in a particular dispute that arose, say, between these two banks about whether one properly paid a client or another. I mean, the range of possibilities, one is classic is you have a huge investment, like when Disneyland Paris was open. And so there could be disputes with each of the subcontractors or with regards to the construction of that. But there also might be disputes with the French government or the local government with regards to that investment. You can have disputes about, say, building a dam, building an airplane, nuclear plants, all kinds of, if you can imagine every kind of aspect of international trade, then disputes can arise. It could be about selling a widget, whatever. And then those go into the arbitration to be resolved if the parties are not able to resolve them themselves beforehand.
So who are the actors who would be involved in an international commercial arbitration?
The main ones are the actual parties. And then we always think of sort of a claimant and a respondent. But in fact, you may have multiple claimants, multiple respondents. If you imagine a construction case where you have an owner who's got a contract with a general contractor, and then you have the general contractor has a series of contracts with subcontractors. So you can have lots of different parties that can, but there is usually a contract that and in that contract, those parties have negotiated an arbitration clause. And there's no place where you have to get the arbitration clause approved. parties are free, just like in contracting, to draft the arbitration clause pretty much any way they want. The only issue is when a dispute arises, is that draft that the parties have done ended up being a good arbitration clause, an arbitration clause that is effective, or does it have problems in it? Sometimes the term used from a guy named Frederick Eisenman, who coined this term, is it a pathological arbitration clause? One way that parties protect themselves is they look to the arbitral institutions, who are, again, in the business of putting arbitrations in motion and having them operate. And they'll use a standard arbitration clause that's provided by the American Arbitration Association or International Chamber of Commerce, worked in Paris. There's London Court of International Arbitration. There's a Chinese International Arbitration Center. There's a Singapore International Arbitration Center. There's Cairo. So all these arbitral institutions around the world that propose their arbitration standard clause that they've concluded will generally be effective to make the arbitration go forward. So first you've got the parties, then you've got the arbitral institutions. Then another key role is that how do you get the tribunal together? So most of the time it's the parties who will name the arbitrators, but what if the parties don't name an arbitrator or something? That's where the institutions may come in and help to put in place the arbitrators. So then you've got the parties, the arbitral tribunal, and the arbitral institutions all playing a role to move the arbitration forward. All of these things happen within a legal framework of each state. And it could be state law, or it could be federal law. And basically the question for each state, meaning each nation, the United States, Canada, and all that, is the general law of that state friendly to arbitration? We call it arbitration-friendly states, encouraging arbitration. Or is the law kind of unfriendly to arbitration, meaning it's a little skeptical? And this is true with regards to international arbitration. To give an example for the United States, one of the reasons that arbitration developed at the beginning of the 20th century was that there was a common law aversion to arbitration clauses. So you'd have a foreign business that had, say, done a deal with an American company, a dispute arose, foreign business would try to start an arbitration, the American company wouldn't participate. And the courts would not enforce those because there was a common law aversion to enforcing arbitration clauses. They would enforce awards because that meant the parties had gone all the way through and made the award. But a party could literally walk away from the arbitration at any point without any consequences. And this affected international trade between the United States and other countries. So I think New York had 50% of the trade at that time. And there were people in New York, and inspired by German law, actually, and others, who developed the New York Arbitration Act, which was to make these arbitration clauses enforceable, reversing the presumption against them that was in the common law. That became the basis for the Federal Arbitration Act in 1926, and when that went into effect in 1926, which made these arbitration clauses valid and enforceable, save for such grounds that are available with regards to any contract, which is part of the language that's there. And that's basically the arbitration law that we have at the federal level in the United States. However, at the state level, the twist here in the United States is that that federal law did not give jurisdiction as a federal question on its own. So the only way that things would get before a sort of a federal court would be if it was diversity jurisdiction or there was some other federal question that was present. And so you kind of had the state law system, and the state courts had played a long traditional role in this area of arbitration. And there were a lot of them that had, again, the common law presumption against arbitration clauses being enforced. And so there was this long process over the 20th century of states enacting arbitration laws that would support arbitration. And this became a real problem for international arbitration when in 1958 New York conference for the New York Convention happened. Because at that time, the United States basically took a very passive approach, even though it participated, because and actually recommended to the United States, the delegation recommended the U.S. government not to be part of that Convention, because I think there were about 25 states that still had the common law presumption against arbitration clauses. And if the federal government was to sign on to the New York Convention, it would have exacerbated tensions between the state and federal government with regards to the federal government preempting the space that normally had been traditionally a space that the states had. So American business actually got put behind at that point compared to our competitors around the world because of that hesitation. And really, there was the business community and others spent a long period of time, probably from 58 to 68, changing local state laws to make them more arbitration friendly, and so to reduce the risk of a federal state tension, you see. And so then by 1968, seeing that we were kind of losing ground to our competitors, the U.S. acceded to this New York Convention, which is really the Magna Carta of international arbitration, and that was under the Johnson administration, so a Democrat, and it actually got passed in 1970 under Nixon, so to make the United States become a member of this treaty. So we lost 12 years, kind of moving ourselves ahead in terms of the state law level, so that we could be competitive on the international level as a country, at least with regards to arbitration. I would say another thing, though, is that the United States has a long history of Supreme Court decisional law that has generally been very favorable to arbitration. I like to describe the Supreme Court decisional law as that there are always these issues that come up, and the end result is, yes, it's arbitrable. And it's pretty much, that seems to be pretty regular for the most part. And the Supreme Court seems to really support party autonomy, the freedom of the parties to choose their law and all those kinds of things. Basically, a narrow view of attacking arbitral awards after they've been rendered. It's kind of like, well, you had your bite at the apple with the arbitrators. If you lost, you lost. And that's made the United States be seen as a very arbitration-friendly country, to be one of the leading, obviously because we're a commercial power, but also being one of the leading powers for moving arbitration, increasing party autonomy and all that. But there are always some quirks along the way with the Supreme Court decisional law. So when you're working in international arbitration and looking at the United States, you really have to not only look at the Federal Arbitration Act, Chapter 1, which is sort of the domestic one, and Chapter 2, which is the New York Convention, and Chapter 3 is the American Convention, but you also have to look at the decisional law of the Supreme Court, which has been going on for 60 odd years, and has generally been very, very, well, actually, I guess 80 odd years, no, 100 years now, my goodness, almost 100 years, have been very pro-arbitration.
Wow. Thank you for that history. That's incredible that it has changed so much, and that it has to change if you want to keep up with business, really, it sounds like.
Yeah. I mean, when you think about it right now, what's the big thing is electronic commerce. Everybody's buying things on Amazon or whatever. I'm not pitching for one company or another. Okay, here I'm just saying, but or business is being done with regards to through Zoom conferences and people signing things and all that, electronic signature issues, all those arbitration is having to adapt to it. The idea of what is a hearing. You used to imagine a hearing, it was sort of three people in a room with two parties and their counsel. Well, no one's in a room anymore since the pandemic has happened. So how do you do a hearing that's going to stand up before the courts when you're doing it through Zoom? Is this a hearing per se? You can obviously get these things done if everybody consents to them. That's the easy way, so to speak. But what if one party doesn't consent? Does that mean that everybody has to go to a room and, do something like run a risk of, a COVID risk? All these kinds of issues are right now being worked out. And what a friend of mine named Amy Schmitz at University of Missouri is called arbitration, or online arbitration. That's one of the things that's just developing through here in this period. Mm-hmm. So, it's always changing, just like international trade is always changing. It's really, and the thing about arbitration that is wonderful is that that party autonomy, that freedom allows for a lot of flexibility, and the institutions tend to want to adapt pretty quickly and, have made suggestions or guidelines about how to deal with arbitration in this environment. And then it's an effort to get the laws and countries in place that they will recognize or modify a little to allow this kind of online arbitration to go forward without there being big issues about, for example, what is it to be heard before the arbitrators? Is that physically before them, or does it mean that you can do it through a Zoom? Those kind of things.
Well, and that leads to a question I had, which was, what are the steps for international commercial arbitration? What can you expect? Like, say you're a lawyer involved in your first international commercial arbitration. What's that going to look like? I mean, I know you said it's flexible. You could do it online. You could do it in person. But what are the main things that you're going to have?
Well, the first thing is you have a client that comes in and talks about some problem that they have. You got to get the contract, right, and see if there's an arbitration clause in it. A lot of times, clients really don't have an understanding of what that clause means. I'm not saying all clients. There are obviously clients that have dealt with this a lot and they know what they are. But in general, you'd be surprised the number of times that it's only when you see the actual contract that you see, oh, there's an arbitration clause. Next thing is, does the arbitration clause specify an arbitral institution? Well, if they do, you've got to look at those institution rules to see how an arbitration gets started in that particular institution set of rules. And so then basically the steps are, the first step is one side sends in sends out something, and to who it sends to depends on the rules, but because it could be you send it to the institution and then the institution sends it on, or you send it to the institution and the other side. So you have to see just how you do the notice of arbitration. And then the question becomes, what should be in that notice? The notice could be really, in some systems, especially if there's no institution, it just might be a notice saying we've got a dispute under contract A and I am appointing Jane Schmo as the arbitrator on my side. Please advise what it is on the other side. Or it can be more elaborate. You can have a request for arbitration in construction case with, 200 different claims and, 90, 100 boxes full of background supporting materials. So there's a lot of flexibility, but it generally starts with this kind of a notice. And there's usually a time period, maybe 30 days or so, and looking for an answer back from the respondent. And then that's again where the respondent would give notice of what its answer is. It may object to jurisdiction. There's a whole, all kinds of issues that could be raised by the respondent, and also about whether they name an arbitrator or not, or what they feel about how many arbitrators should decide the case. So that starts the process of getting the tribunal in place. For the tribunal, the issue is going to be, are they independent? Are they impartial? If somebody names as an arbitrator the sister of the CEO of the company, obviously there's some issues that are there with regards to that. And then once the arbitrators get in place, which may be that the two arbitrators would name the chair, or it could be that everyone agrees on a sole arbitrator, just one person hearing the case, then there's always the question of how much this is going to cost, making sure money is paid in, and then pretty much the arbitration goes into the hands of the arbitrators. Now, one thing that if you're new to arbitration, you should understand is that if somebody on the other side, looking very sophisticated and understanding, says, so should we use the usual rules, and you don't want to look like you're stupid and you say, well, of course, there are no usual rules, okay? Just understand, there are no usual rules. So everything is up for negotiation as to the procedures, and most of the arbitral institutions' rules give this great flexibility for the parties to agree the procedures, or failing that the arbitrators decide. So the procedural battle ends up being a huge part of this. How is evidence going to be presented? Are there going to be additional briefs? How are witnesses going to be heard? Are you going to have direct examination of witnesses, or is it just going to be a witness statement? Are we just going to, how's cross-examination supposed to be done? Would there be an expert to come in, or experts by both sides that would come in and look at whatever was the widget or whatever the problem was to determine what was there. How do we deal with like in intellectual property or trade secrets? How do we protect their confidentiality with regards to what's going on in the arbitration? Have the parties agreed what law applies? If they haven't, what law will have to be applied? Is there a jurisdictional issue that the parties are raising with regards to one party saying that, you know, this is not properly before this tribunal? How do we decide the jurisdictional issue? Then there's the merits of each of the claims, and the arbitrators deliberate and they come to their award. Is there going to be a dissent by one arbitrator or not, and what to do with that dissent? All those kind of things. And then, believe it or not, while you're thinking about all this as starting your arbitration, you're thinking about where could this arbitration award, if we win, where would I want to enforce it? Am I going to enforce it here in the United States? Am I going to enforce it in Canada? How do the Canadian courts look at arbitration awards? Are they comfortable with online arbitration? Or are they a little reticent about it? Maybe it could be the courts in Egypt, or it could be the courts in Germany, or the courts in Singapore. Again, looking forward to where you'd want to enforce the award. What are the attitudes of the courts that might have to look at the end product of this arbitration? And can I make sure that I put in place an arbitration as one party to the best that I can, that will be something that would be acceptable to any of the courts where I might seek to enforce the arbitral award? Those are the kind of things that that would be the kind of thing that you would sort of walk through, trying to, as the client comes in the door, and obviously the client won't understand all of that stuff because there's a lot going on there, but that's what you're thinking about. If you're going to have a foreign law, how are you going to present the foreign law? Do you need to have, say, if it's German law, you need to have a German counsel help you? I mean, you can't possibly, as an American, learn German law in time. So you'll need a German counsel to help you, someone who knows it. Just like a German lawyer would be a fool to think that they could understand American law. This goes back to what Professor Korzun has said is about the national systems that you have to be aware of. So, figuring out how to organize that. There's no particular rules that are set on those things, but you have to think them through very carefully to put the best foot forward for your client, and not by a mistake of some kind agree to a set of rules with the other side that ends up putting you in a position that is unfavorable for your client. I can give you an example. Just comes to mind is, say you have an expert who is, a tremendous expert, really knowledgeable and really powerful presence. Well, that might be a setting where you'd want that person to have direct examination of that person, where they would present all their arguments and their wonderfulness and their gravitas and all that stuff. But if you've agreed ahead of time to just have witness statements, only thing that the people will see is them responding under cross-examination. So you kind of lost that tool to emphasize your client's position. Those are all kinds of decisions like that you have to make tactically to try to put the best foot forward for your client.
So it sounds like it gets so much more complicated when arbitration is used across counties. So you have to worry about what was in the arbitration clause, the arbitral institutional rules, the national arbitration laws that are going to be in effect, and any kind of international things that are going on, agreements or
right.
Anything going on. It's a lot to juggle. If you're an international lawyer, it sounds like you should definitely know about arbitration too.
Yeah, I mean, really, when people are doing their deals, I remember a friend once said to me that, there's the economics of a deal, and then there's just two clauses that are really the heart of the deal. One is how you get out of the deal, and second is how you resolve disputes. Okay, and so if you don't have it clear on how to get out of the deal, you're definitely going to want to have something clear on how disputes are going to be resolved. And that's really, it's almost would be malpractice to not have an arbitration clause in there, because just imagine you don't have an arbitration clause and you're an American company and you want to have a dispute with, let's pick a country with with a Polish company, okay? And there's a dispute about what the Polish company did. Well, so how do you go about suing them? You know, what do you know about what the Polish system of courts is there? Can you get this jurisdiction over this Polish, any personal jurisdiction in an American court? Even if you get it in a jurisdiction in American court, the only thing you got is a judgment from an American court, which might be appealed. And then let's say the judgment is fine in America, but now you're trying to enforce it against that Polish company in Poland. Well, how are the Polish courts going to look at that American judgment? Are they going to say, out of sort of friendliness and comedy, okay, we're going to enforce this? Or are they going to want you to relitigate the whole thing in front of the Polish courts? Those are all kinds of things that can happen if you don't have an arbitration clause. If you have an arbitration clause, you have that award that was rendered somewhere, and you come to Poland with that award and say, here it is, court. And the court says, okay, and then there are the limited grounds on which to attack the award. And then that Polish court, if it's arbitration friendly, you get into all kinds of issues about each court's culture towards arbitration, but more likely to enforce that arbitral award than to be accepting of an American judgment from an American court. It's just really, you're putting yourself at a disadvantage not having an arbitration clause for those kinds of, once you go cross national lines, cross borders, you really need to have an arbitration clause.
If I may jump here,
please
perhaps.
do.
Yeah. I was just, I wanted to, there are so many thoughts that I have after I've heard you, Professor Davis, and I couldn't agree more with you in terms of, for instance, how important it is for somebody who's just experiencing arbitration for the first time to pick up a contract and get acquainted with the substance of the arbitration provision, because we discussed it here today. There are at least, they say, 5 different systems of law or rules that are applicable to any given arbitration. And technically, arbitration clause itself is separable from the agreement where it's located. So it could be subject to a different substantive set of rules because it's an agreement of its own. So you end up having at least, one law that governs the arbitration agreement because it's a contract to arbitrate, right? Then you have a law, what we call, lex arbitri, the law that would govern how the arbitration itself proceeds, sort of, let's call it a procedure, more or less. Then you have the law that is to be applied by arbitral tribunal to the substance of the party's dispute. So, if they're disputing about the price in the contract, what is the substantive law, whether it's a contracts law of Ohio or it's a contracts law of Germany. Then, of course, there are various non-binding rules that parties can incorporate. And Professor Davis mentioned, the need to have independent and unbiased arbitral tribunals. And, for instance, International Bar Association has developed, guidelines on conflicts of interest in this respect. And you can subject your arbitration, specifically arbitral tribunal members, to these provisions by choice, right? And then when you're at the end of this process, hopefully when you have an arbitral award, 2 things can happen. You can try to vacate this award, and usually there is only one place in the world, with some exceptions, but general view is that it's at the place of arbitration, where you can go and ask the court to set it aside, so to speak. So you don't have an appeal, but you can annul it if you're lucky. And then the other party, of course, who's the winner in arbitration, they would want to enforce the arbitral award. And this is where 1958 New York Convention on the recognition and enforcement of foreign arbitral awards kicks in. So you have the level of interplay between domestic contracts law, rules of arbitration institutions that I forgot to mention, and then of course IBA guidelines and finally treaties. And all of them have different role to play. Some of them are assisting tribunal and parties from the point of view of procedure, so to speak. Some of them assisting tribunals in applying the substantive law to the conflict itself and resolving the substance of the dispute. And some of these rules are here to assist the winner to enforce or the loser to kill an arbitral award. So it's very much a complex set of rules, and why it's important to look at the arbitration clause, because it will be your starting point, at least from the point of view of a contract, right? Since you have 2 parties in this particular commercial transaction who want to have their disputes to be resolved in arbitration, ideally, they would tell you in the contract itself what kind of arbitration they want. And if they went and decided to use an institutional arbitration, they would make a reference to these institutions that Professor Davis has suggested, such as International Chamber of Commerce, that have their own set of arbitration rules. And I hear there is a new edition coming from January next year. So you sort of incorporate their rules by reference, and it's probably an easier way to structure your arbitration by reference to the institutional rules, because they would give you default provisions. And so when you have an actual arbitration, you don't need necessarily to negotiate with the opposing party in the dispute, because the institutional rules would give you answers in many of these, deadlock situations. But you can also structure your arbitration clause from scratch without any reference to any rules. And then probably it's hard to do it in a comprehensive manner unless you have, after the fact, when you have a dispute already, decided to go to arbitration, which you can do. And then I assume if everyone is willing, you could sit and negotiate an arbitration agreement with all the details that you want there to be included, which rarely happens because, you're already disputing on the substance. So why would you agree on the arbitration in all the details? But even in those instances, you could incorporate, ancestral arbitration rules. So you don't have an institution who would assist you with your arbitration, but at least the set of rules would be available for you to incorporate. And, it's a nice way to provide for all the contingencies that you might face in arbitration. It's a fascinating area, if you ask me, because of all these, complexities. And also, in one way or another, there is this bridging the gaps, so to speak, because you bring civil law and common law lawyers in a single room, be it virtual or real one, and, ask them to assist parties to resolve their dispute.
One case that was brought up in the PowerPoint that you two were originally going to present at the symposium was Friedman versus Cosmer from 1995. What does that case teach us, and why does that show the complexity that you've both been talking about here?
I like that case. I took it from one of the arbitration case books because you basically have these two French persons who have a dispute about the price of selling shares between them, I believe it was. And so one of them brought a lawsuit in a state court in New York at the time. And the other one said this was arbitration, and so had the case removed to the federal court. And so as a federal question in the New York Convention, is an international matter. And one of the questions for that federal court was whether it had jurisdiction. Is this an international arbitration under the rules of pursuant to the New York Convention and all? And so what the federal court had to do was to, first of all, between these French parties, this contract was signed in France, they had to figure out, well, what is this thing that they're talking about, this appraisal of a price for this contract, And so they went and looked at the American court, went and looked at what the French law of arbitration was. And what the French, and in French law, it is called price arbitration, the kind of thing we're talking about here. But the way the French arbitration system looks at it is not as something that leads to an award. It leads to a judgment of a kind. And if you were to not be happy with what came out of that appraisal in France, you would basically go to one court, which is the lowest level court, to attack the decision that was made by this appraisal person, as opposed to the courts where you go if you're attacking an arbitral award to try to set it aside that we're talking about. So there are all these differences in, even though the word arbitration is used in French, there are actually these differences between what is French arbitration of the kind we've been talking about and this price appraisal thing. So this is an American judge looking at this French system and then saying, okay, so given that, is this really an arbitration in the United States under the New York Convention? And the conclusion was what was going on in this clause would not be arbitration in France. And so as a consequence, that being the proper law to look at this, I shouldn't see this as an arbitration in the United States. Therefore, I don't have jurisdiction because it's not under the New York Convention. Therefore, you're remanded back to the state court, But this is the American judge going through all these hoops to try to figure out this thing that came into to the tribunal that they just had to figure out, If you imagine an arbitrator, let's imagine the arbitration is in a contract that says, I don't know, New York law applies. All right, but the arbitration clause says French law of arbitration applies. So, and the arbitrator is sitting in, let's pick a nice little town. Milan, there, we'll pick Milan, Italy, right? So now the arbitrator is sitting in Milan, trying to figure out how to do an arbitration under the French arbitration system and French law with regard to the substantive law being New York law. You see? You say, well, why would people do all that? Well, I understand, but there's that freedom, okay? There's the freedom. In fact, you can get into real problems. For example, you negotiate really toughly and you agree that the contract will be subject to Swiss law. I remember this actually happened. Then you get to the arbitration clause, and the point was that the arbitration clause was going to be covered by Iranian law. Well, great. It was a contract with an Iranian state-owned enterprise. It just turned out there was an Iranian intern at the embassy, and I said, is there any problem with that? Because I got asked about this by somebody who was going into a meeting, and the Iranian said, oh my goodness, that's a disaster, because under Iranian law, arbitration clauses can only be entered into after there's the approval of the Iranian parliament, okay? So the effect of this clause, even though you think you have Swiss law applying to your contract, is the arbitration clause is ineffective because it hasn't been approved by the by the Iranian parliament. And so you have no arbitration clause, although you see one, but by that choice of Iranian law, it disappears unless you get that approval of the parliament of Iran. You see, those kinds of games can be played. And unless you're kind of really up on it, you got or get an advisor from that country to give you the implications of all these things. You're going to run into, you can all of a sudden find yourself kind of caught out at the moment that the dispute's arisen. And that goes to another thing, which I like to add on, is negotiation. I do know that if you have a bad arbitration clause, there are lawyers who will call up the other side and say, look, you see this arbitration clause in our contract, I can hold this thing up for 3 years because I know all the kind of things that I can do to mess this thing up so you won't see any money for 3 years. So why don't we talk about negotiation of, instead of maybe 50 cents on the dollar, you get 10 cents on the dollar of your claim. And somebody might take that deal because just the arbitration clause has messed it up.
If I may ask you, Professor Davis, do you feel that the biggest difference here is that people who negotiate the substance of the deal are so much focused on the transactional part of the deal and want it done, that they sort of copy-paste arbitration at the end without giving it much thought? And then from the litigation, focused folks who understand much better how arbitration operates, it's a big problem. And so I think maybe what is your view?
Yeah, the champagne is on ice, right, on the deal. And the heads of both companies are ready to sign the thing and have the photo opportunity and all that. And then you've got this lawyer who is saying, well, I think we need to talk about disputes. There will never be disputes between everyone's in love, right? Everything's wonderful. But, you've got to be that person, the sort of the fly on the soup, who is really actually thinking about what is the structure of dispute resolution that has to be put in place. And there is the risk that there was a clause that worked before, I'll just use it again, right? But every contract's a different situation, right? For example, French law might be great in a certain kind of setting and disastrous in another one. Or German law might be great in a certain setting, but disastrous in another. And those are things that you can't just at the last minute while the champagne is on ice, think through and negotiate. When you have a big investment like I remember when Disney Paris, this arbitration clause went on for 4 or 5 pages, single space, on different issues. If if Disney brought a lawsuit against brought an arbitration against the general contractor and it related to some work done by a subcontractor, then the subcontractor could, within 90 days, say they want to be in the arbitration. So now you have the three, and then in that case, the arbitrators will be named this way. You know, all this kind of stuff that was thought through to recognize the complexity of building a 2,000 hectare amusement park in near Paris, you know. And all of that is, you know, it's really, I can't tell you enough about actually thinking it through, you know.
Yeah. And I agree with you. I mean, you already mentioned this, a number of arbitral institutions have put together various sample clauses, and there are options there, right? You can go for straightforward arbitration if you want to, have a more complex dispute resolution in your contract. You could go for this more complex provisions, such as starting with negotiations, moving up to negotiation, and then proceeding with arbitration. And those options are also available. What I have seen as a problem sometimes, students, for instance, they become creative in drafting classes, and they try to borrow what they perceive to be better features from different institutions, and that can create troubles. Like ICC that you have experienced with, Professor Davis, they have this scrutiny. Effectively, they're the only one who have this scrutiny procedure among institutions. So they look at the award after it's rendered by arbitral tribunal and verify that some elements of the award are present. And it could be as simple as, mathematical error, but it could be also whether all of the issues that have been submitted to arbitration have been addressed. And so now imagine that students like this idea, but they want American Arbitration Association or any other institution to do this type of scrutiny, but they are not equipped to do it. There is nothing in their rules to do the scrutiny. And so mixing and matching institutions is not the best idea. I now see the International Chamber of Commerce specifically says that it's only us, ICC, who can administer ICC arbitration rules. American Arbitration Association, with regard to their international rule, don't have this. So supposedly you can borrow from them, but ICC is very protective, and I see why. So drafting is an important thing to consider here.
Yeah, and one of the things that really struck me at the ICC is that whenever any award comes out, there's a lot of notification done by the ICC itself as opposed to the parties for the request and the answer and the award. And when the award comes out, it's put in a binder that says ICC on it and gives the names of the parties, right? Well, those binders have been going on the ICC since, I don't know, maybe 1925, 26 or so. And so courts are used to seeing an ICC binder if it's ever being attacked. And it's like it was like a brand, that the way they would look at that award, oh, that's an ICC award. With the scrutiny and all that stuff being part of it. And psychologically, the view is that those awards would tend to be treated more favorably because they know that the whole process of review was in that. I don't know if it's true, but you did have that look of this sort of special, this is a special, it's not just some award without any cover on it, it's just, so this is an instrument,
Sorry, I just want to make sure we turn to how and why the U.S. courts are getting involved in international commercial arbitration. And I definitely wanted to talk with Professor Korzun about an empirical study that you were a part of about border crossings. Now, tell us about border crossings, because I don't think it's when I take my passport to Canada. What do you mean when you say border crossing?
Well, I think we have already a perfect introduction to this discussion. Maybe for our listeners, we have made an impression at the beginning of this talk that arbitration is an alternative to court litigation. And this is like neutral dispute resolution procedure that doesn't have an oversight by courts. And, case books often start with arbitration being alternative. And so this alternative view on arbitration is sometimes perceived as being completely independent from court's oversight. But what my study here with a colleague of mine has shown, and people knew this already, but maybe not in all the aspects that I want to address here, So what the study has showed is that, well, frankly, it's more proper nowadays to view arbitration and courts as working in the partnership when it comes to arbitration. So arbitration can proceed perfectly on its own when everything has been provided for. There are no disputes as to procedure, and both parties want to have the dispute to be entirely, addressed in arbitration and then voluntarily comply with the award. But there are so many things that can go wrong in arbitration, from what we already mentioned, such as, drawbacks, so to speak, in the arbitration clause, so that it's unclear what type of arbitration, for instance, the parties wanted, or what is the procedure to be followed. And so because of these things that can go wrong, essentially, there is a bigger role that courts have to play. And it's not only American courts, not only state and federal courts in the United States. Any courts in any part of the world can have a number of things where they can help the parties, and also tribunals and sometimes institutions. And so border crossings here are effectively these interactions between arbitration as a separate binding dispute resolution method and courts. And so there is no negative connotation when I say border crossing. I'm just using this term to talk about interactions or partnership between the two. And we have the slides that I understand will be posted on the court website, but you could also take as a reference, for instance, the ancestral model law on international commercial arbitration and just analyze the provisions. And you will see that there are a number of provisions there that indicate how courts can be helpful to international arbitrations. And so in my study, we used international rules that I just mentioned, the model law of the ancestral, and ancestral stands for the United Nations Commission on International Trade Law. They developed various rules important for international business, and in specific reference to arbitration, they also have a model law on international commercial arbitration that sovereign states can adopt. And ancestral also published and revised ancestral arbitration rules that disputing parties can incorporate and use for their specific arbitration. And so based on this model law, for instance, there are at least 10 types of border crossings. And then we added one more. And I won't be listing all of them, but I just want to give you an example. For instance, you might have an arbitration clause in a sale of good contract, and we're talking about international sale of good contract, where it's unclear, for instance, what is the arbitration that the parties want and whether they want arbitration at all. A funny example, Professor Davis mentioned this, a language plays a bigger role. And so, for instance, in the Russian Federation, the economic courts are referred to, effectively, if you translate it into English, as arbitral courts. And so, you read this name of the institution, and let's say the parties want their dispute to be resolved by the arbitration court in Moscow, Russian Federation. And depending how it's phrased, it might be our standard international commercial arbitration that we are talking about here, or it can be a permanent state court that deals with economic matters in Russia. And so if you have a dispute as to what exactly this provision calls for, and one party says, of course, we wanted to have alternative international commercial arbitration to be held in Russia, and the other party says, no, of course, we wanted it to be submitted to a permanent court that deals with economic matters based in Russia, you might end having this dispute that has to be resolved by the court before parties can actually proceed in arbitration, or before they can stay in court. And so this enforcement of the arbitration agreement or arbitration clause, a provision in the contract that calls for arbitration, here you have a direct role that courts would play. So you thought you wanted arbitration, but it ends up, it's not given that it's an arbitration, there is a dispute, and this dispute might be resolved by courts. Provisional measures, there is a big trend nowadays, I hear, and if you compare institutional rules on arbitration across different institutions, over time, they added various provisions that allow arbitral tribunals to issue interim measures. But you need to appoint arbitral tribunal for one, to be able to call on them to issue, an interim or provisional measure that you want to have. And so sometimes, depending on the rules chosen by the parties or depending on the stage of the dispute, you might have to go to courts. And it can be the courts where the assets are located. It can be the courts where arbitration are, meant to be held. But courts would have a role here with these provisional measures, and it's not enough that you agreed on arbitration. You're sort of forced to go back to courts and ask for their assistance. Appointment of arbitrators. Sometimes it's left to the courts. Of course, if you have an arbitral institution, maybe, and they can assist you depending on the rules. But occasionally, if there are disputes about who would be your arbitrator, again, you have to go to court, and court might be able to assist you with the appointment of arbitrators. Challenges of the arbitrators, it's the opposite, if you think that they're biased and non-neutral and have direct interest and they refuse to step down effectively. Some courts across the globe will assist you to, remove arbitral tribunal and reappoint somebody else. And I said I won't mention all 11 that we have identified. You can, of course, break them down differently. But some of these border crossings, like going back and forth from arbitration to courts and then potentially going back, are sort of self-evident if you look at the New York Convention. So New York Convention is, of course, the convention that assists the parties with the recognition and enforcement foreign arbitral awards. So if the loser in arbitration does not want to pay, you might need to, hunt essentially for their assets around the world. And you would use the New York Convention that gives you a procedure for going locally to courts, presenting an arbitration agreement and an arbitral award, and asking for the recognition and enforcement so that you can enforce this award locally. And secondly, the New York Convention doesn't talk a lot about this, but it recognized the availability of the annulment of the arbitration award at the place of arbitration. And so this is what I mentioned before, but the ability of the award loser to go at the place of arbitration and ask the court for annulment of the arbitral award is something that, again, you need to have courts engaged in. And so with that big introduction, I just want to describe a little bit of the study that we have conducted. So we looked here at the Southern District of New York, and we wanted to analyze.
Why did you pick the Southern District of New York?
Well, it's a logical location. This is where many arbitration have, seats. It includes Manhattan. So, when you have hearings, when you have proceedings, parties choose New York as the seat of arbitration. This is a very popular location for, international arbitration specifically. And then, of course, award winners come to New York to enforce. So you might expect enforcement proceedings in New York as well.
Okay.
And we analyzed based on, these 11 categories, and we used Westlaw. You do your search, and in my paper on this subject, we described how we conducted the search and what were the key terms and how we counted the cases. And based on reading the cases and classifying them, we tried to identify what are the most frequently used border crossings. We also looked for, very active users of border crossings, like coming back to court several times. And it could be at the initial stage to ask for the enforcement of the arbitration provision. It could be the initial stage to ask for the interim measure. And it could be at the back end asking for the enforcement of the arbitral award. And we, counted cases and tried to do some predictions as to what would be the areas that will grow. And so I'll just underline a few conclusions here. So, of course, as you could expect, based on the New York Convention, the most frequently used border crossings were instances where parties have asked court to enforce arbitration agreement. So 32 observations, or 32% of cases that we located had to do with the enforcement of the arbitration agreement. This is what happens normally at the end of the arbitration proceedings. And 35% were actions based on the New York Convention to recognize and enforce arbitral awards. So this is logical, so to speak, right? at least logical for people who are in arbitration world, because frankly, New York Convention is one of the most successful treaties in the world. And one of the reasons why arbitration is so successful, and it gives procedure that can be used for the recognition and enforcement of agreements and awards on the other hand. There are other border crossings which are relatively frequent, but they are far behind, if we compare them with the top ones that I've just mentioned. So actions to seek interim measures, only 13% of observations that we had to do with interim measures request. And actions to set aside arbitral award, to annul arbitral award, we only count in 7% of those. And I just want to note here that interim measures and ability to request provisional measures from arbitral tribunals as well as from domestic courts is a hot topic. If you look at the revision of arbitration rules by arbitral institutions, I think everyone have rules nowadays that suggest that, yes, you can ask for interim measures from the tribunal itself. And secondly, there are provisions that says, well, if tribunal is unable to enforce these orders with regard to interim measures, you should be able to go to local courts and ask for enforcement. And so I would expect more cases of this sort in the Southern District of New York, considering how popular this discussion is and, how developed rules are. But maybe it's something that will grow. And so this was, one of the statements that we made with regard to the future and developments in this field. And setting aside, maybe it's surprising that there are so few awards being set aside in New York, but I think it comes back to what Professor Davis has suggested. There are some jurisdictions which are notoriously arbitration friendly, and frankly, New York would not be the best place if you would like to set aside an arbitral award. It's very hard to do it. Normally, it has to do with the procedural inequality of the parties, and arbitration conducted without putting the other side on notice that arbitration was commenced. It's those extreme cases. So in New York, it's not easy to set aside an arbitral award, and maybe this is the reason why parties don't bring these actions in New York. It might be different in other jurisdictions. And so, this was the study, and it showed you that our view on independence of international commercial arbitration and it to be an alternative to court litigation has to be slightly adjusted, because there is so much interaction between courts and so much help that they can and are providing to international arbitration that I think it's more, properly to talk about those as a partnership between the two.
Well, thank you for outlining the trends and the role of the U.S. courts in international commercial arbitration. Just thinking about Ohio, there's about 30 courts in Ohio that have an arbitration rule, but it doesn't seem like it's used that widely in Ohio. Do you think arbitration can fit into Ohio? And do you think more practitioners here should learn about arbitration? Are there benefits locally to using arbitration?
I mean, from the international perspective, yes, of course, but, we're talking about international here. And so arbitration itself is, of course, the product of contract. And so when parties choose how to structure their arbitration, which rules to use, and of course, when they choose the seat of arbitration, this place of arbitration that has a legal meaning, the local law and local courts will have a supervisory role over international arbitration if the seat is in Ohio, for instance. So I say one of the reasons why Ohio has a place to play in arbitration is having nice and developed international arbitration rules. I looked up today at the code, and there are some provisions there that other states don't have with regard, for instance, with provision of interim measures that can be provided here to assist, international arbitration. But of course, parties have a role to play. And so if they don't choose Ohio, but they choose something else, they effectively remove, Ohio courts from engaging in assisting international arbitration here. But coming back to interim measures, if the assets are located here and you naturally need to come to Ohio to secure these assets while arbitration is ongoing, It's just a matter of, location of the assets and actual facts of the case. And so this is what my view is on that. I don't know, Professor Davis.
Yeah, the only thing that I would say is to add on that would be I did a quick search of how many U.S. states have passed the UNCITRAL model law on arbitration as their state international arbitration law. And I found 8 here: California, Connecticut, Florida, Georgia, Illinois, Louisiana, Oregon, and Texas. And I do know that Florida and Georgia have been putting in a lot of effort to try to become international arbitration centers. And so, one of the reasons for why passing a law like that is that around the world, people know what the UNCITRAL model law is. They don't know the Ohio particular version. So if you could say for Ohio, oh, well, we have the UNCITRAL model law as our state arbitration law, it comforts somebody from around the world. I know what that is, or I think I know what that is, as opposed to what may be a perfectly valid Ohio law, but it's kind of a mystery towards for somebody from another country. And even saying that, though, you have to look at the actual draft of the law as passed by the legislature, because there's sometimes people put a few quirks in there. Around the world, there's a lot of countries that say, oh, yes, we have the UNCITRAL model law on arbitration. But when you look inside the law, you find there are a few local quirks that actually may be a little less arbitration friendly than that law in its draft form is said. But, that's the kind of thing Ohio could do to build the arbitration capacity here. A second thing that I think I did in Florida is to create a sort of almost like an arbitration chamber in the courts, where there were specialists in international arbitration that would be the ones who would hear the cases for setting aside or enforcing an arbitral award. So that, it's a question of the quantity of business that would happen for that particular chamber. But those are the kind of things on the theory that those judges would develop a certain expertise in these kinds of issues. And so therefore they would be more adept at addressing them. I think there are chambers that sort of like business chambers and things like that. Well, this is just kind of another version of it. I think they did this in Miami, if I can remember right, as part of these kinds of efforts to make one be perceived as arbitration friendly and therefore business friendly as a court. So
this is it's a great idea. It's a sort of, yes, you need a little bit advertise yourself in this sense. And so once the users of arbitration will feel comfortable that this is the place where arbitration is generally recognized, I think you would see more cases that have to do with the higher, like we talked about this, Professor Davis talked about arbitrability of the subject matter. And laws around the world very much differ in terms of the scope of arbitrability. Like for a while, I was interested in the question of arbitration of antitrust or competition law disputes. And of course, we have the Supreme Court decision in Mitsubishi here that has long told us that competition or antitrust matters are arbitrable. Some countries around the globe still have exceptions with this regard. And so you end up having a, let's say, contractual dispute. And let's say there is a claim of a breach, but other side raises a defense saying, yeah, but our contract is in violation of antitrust laws. So if your arbitration law does not allow you to talk about antitrust in arbitration, you effectively have to do two proceedings. A contractual dispute, a breach claim will still be addressed in arbitration. A defense that ideally you would want to raise here to invalidate contract as a whole would have to be somehow litigated in courts. We don't have this restraint. So in terms of subject matter, the joke is that everything is arbitrable in the United States. But I think what Professor Davis is also referring to is the question of, how courts view international arbitration and whether they will interpret the grounds for setting aside international arbitral awards too broadly or not. And so maybe here, there is a role for us to advertise Ohio and Ohio courts in this sense. And of course, also make it more visible so that parties who draft arbitration agreement won't be afraid to put, let's say, Cleveland, Ohio as the seat of arbitration. And when you do this, now you're subject to the supervisory role, and this would be the place where you can ask courts for annulment or not. And so this is how international arbitration, gravitates to places such as Ohio.
It's so interesting to think about the opportunities that might be here. Well, we're almost at the end of our time here. So there's a bit that I like to try at the end of every podcast that we're doing in this series, and it's called 2 for me and 1 for you. There will be 2 questions for the presenters and 1 question that they will have for you, our audience, as a kind of pop quiz to see if you were paying attention today. So first to Professor Davis, question 1 is what's an interesting and relatively brief arbitration story you can share?
Interesting and relatively brief arbitration story. Well, brief. How about a fast track arbitration for maybe $300 million done in 80 days? Okay.
Nice.
And this is where a secretary came into my office. I'd been there for a while and said, we've given these cases to this other person, but they're kind of new, and maybe you want to take a look at them and take them over. And I asked my assistant and secretary, and they said, yeah, okay. So talked to the guy, and he said, sure. And before the files got to my desk, there was a phone call from one of the parties saying, so when is this going before the court? And I was like, can I read the file, please? But it was about a price being determined between Canada and the United States for, I think it was heating oil or gas for that winter. They normally would agree this, but this time they didn't agree. And so they had to use this process. So was a pretty amazing experience over one Christmas where we got that all set up, all these things we talked about with all the complications that we talked about, to an award in 80 days. And that was, may seem like a long time, but trust me, if 30 days are just getting the answer, and, it was, and there were 4 different arbitrations, and, it was fun. That was amazing.
Around the world in 80 days, international commercial arbitration.
There you go.
How about you, Professor Korzun?
I don't know if we have students listening to us, but I just want to say that arbitration is itself an amazing story with all the complexity of laws that are involved. Diversity of people. I mean, it's not a perfect method of dispute resolution, and diversity and transparency might be improved or shall be improved in this area, of course, but you end up talking to people from different legal traditions, resolving disputes from, businesses coming from different parts of the world. You have variety of laws, languages, different tactics and techniques used in cases. And it's all ideally to be able to resolve disputes and allow business parties to proceed. Sometimes it can be as small as figuring out the price and then continue business relations. And so arbitration really has lots to offer. So if you are considering whether to, pick up this law practice and get involved, just do it. You wouldn't regret.
Right. All right, Professor Davis, question 2. Who is an amazing person related to arbitration or dispute resolution, and why do you appreciate them?
Oh, well, they've passed away now. So the one that comes to my mind was the president of the ICC court when I first got there in '86. Is a guy named Michel Godet. He was one of the founders of the European community back in the 50s after World War II. He was actually the first legal advisor for the European community in '58. And so now I got to start to work there in 1986. And, I remember I had a very complicated case and I was trying to prepare a file for him. And he said to me, Mr. Davis, I don't need a file. It's your case. And all of a sudden I was, barely 2 weeks into the job. And, he showed this confidence and expectation and high standards about what I was trying to do. And thing about him is that he was very much, going along with what Professor Korzun has said, very much into dialogue between peoples from different parts of the world. He created a East-West arbitration group for Eastern European and Western European folks to dialogue, and various things that he would try to reach out around the world. And he was an enormous spirit who made everybody feel like you were special, and that he expected much of you, but he had confidence that you were able to do that. And, he was kind of an amazing fellow. One of his lines, he once said was, it's what we do together that will make the difference. I was like, wow, huh? Isn't that something? So that's the one that I just jumped to mind. Obviously one of my heroes, and learned a lot from him.
That's great. Thank you. And Professor Korzun, who would you like to give a shout out to? Who's an amazing person related to dispute resolution and arbitration that you would like to talk about?
Yeah, I would name my professor as well. So there is somebody by name Tibor Vardi. I hope he hears us now. Yes, he was my professor a long time ago at Central European University in Budapest, Hungary. And I actually didn't take his international arbitration class. I was a transfer student, but by the time I joined, they already had this course offered. But I took his international business transaction course. And I remember how shaken I was when I had to speak for the first time in his class. And I remember it was a sale of goods contract and I couldn't start. Everyone is looking at me. They know each other. I'm a new person. And I said, well, there is a seller and a buyer. And then I paused for a second and he joked back saying, well, it would be a big surprise if you wouldn't have a seller and a buyer in a sales contract, something of this sort. And it loosened me right away. And, I could collect myself. And I really enjoyed his class. He's an amazing legal scholar. He is an active arbitrator. He's an amazing professor. He's a Harvard Law grad, but of course, he is originally born in ex-Yugoslavia. And then he spent much of his work in Europe. And, he published over 200 articles and other publications throughout his career and even literary work. And he has one of these best books that at least we used at the time, written in arbitration together with his colleagues, I think from Cornell and Harvard. And so, Tibor Vardi, he really is the person because of whom I'm interested in international business law and international arbitration.
All right. And thank you. And our last question, and one of you could answer this, I guess, is to give our audience a knowledge check. What's a pop quiz question that they should be able to answer after listening to your podcast?
What are border crossings? What are border crossings?
There we go. All right.
I like it. Thank you. All right. Well, we've reached the end of the podcast, but I wanted to give a chance for you to make any closing statement that you wanted to before we sign off.
What I would say is that all of this may sound very complicated, but if somehow someone out there is kind of interested, bitten by the bug, by what we've talked about, that is good. You are not crazy. It is very good. And I want to encourage you to explore a path to how to get to do more and more of this stuff. Because it's really rewarding. And the interactions with people from all over the world, I found always quite amazing and moving. We see how we all are very similar and we all have our differences. But the dialogue with all the people is so enriching for you.
And I couldn't agree more. I would also say that with all the complexity, it's a very interesting field to be. It also difficult from the outsider to explore because of the transparency and confidentiality of the arbitral proceedings that might be involved. So if you are able to find a mentor for yourself and to work for somebody who already has experience and practices in the area of international arbitration, I think this would be the most valuable experience you could get. So, try to find such person and learn from him or her. This would be, I think, my biggest advice in this sense.
Well, thank you. Thank you, both of you. Professor Benjamin Davis and Professor Vera Korzun. Thank you for being here today. Thank you for our audience for listening. and to everyone out there who is working for justice. Thank you for having us.
Thank you. Thank you very much.